This show is proudly brought to you by Veza Properties. We're gonna give you information. You'll get to understand the new things that are happening in the property industry. So especially if you are a property practitioner, we'd call you. We used to call them estate agents. If you are actively in the property profession, this is your show. We've got Gretchen from STBB. She is our expert today, Gretchen Enslin. I hope I'm pronouncing everything correctly. She is with Pamela Makubela. I'm sorry, I'm laughing because I called him Mpumi and she's not Mpumi, she's Pamela.
How did you get to Mpumi?
Well, I happen to see faces and place names on people. She looks like Mpumelelo, which means success.
Fun.
So we're going to get hold of Gretchen today. We actually discussing the new Property Practitioners Act that is coming into effect on the 1st of February. On Tuesday.
Mm-hmm.
That's so soon. So this when this thing was put out there, I think it was in 2019, and it's now an act. So we're going to get into it, break it down, and make you understand how does it affect you as a seller, as a buyer, as a property practitioner, and bond originators as well. So have we got Gretchen on the line there, Zen?
Not yet.
Okay.
We still need to expand a little bit more on what we have in store and what our listeners have to
look forward to. Yeah.
And I know you did a bit of research about it before you actually printed this lovely little
before we
script
came
we
here.
have.
Yeah.
So what did you find was the most let me say weird thing that they actually edited and actually made it a rule within the property space? Like, I know they changed quite a few things. A few people that weren't necessarily regarded as property practitioners are now regarded as property practitioners.
True.
Which one was the most shocking for you?
I think what is what I would like to understand, like I wish I had spoken to this person who did this act. It's they classify home loan consultants from the bank as non-property practitioners, whereas home loans from bond origination companies are classified as property practitioners. So maybe our experts will also explain to us, like, why is that necessary? But I understand it's because of the banks are governed by different rules from bond originators.
Yes, they have their own regulator. So I suppose then they're already regulated to a degree, so they don't necessarily have like a double barrel regulation in case they clash at some point. So, Bridget, we have Gretchen here on the line.
And Pamela. Gretchen and Pamela, hey ladies, are you with us? How are you doing?
Hi there. Hi guys.
How are you doing?
We're doing great, thank you.
We're doing well, thank you. How are you guys doing?
We're good. I think we're going to start off by maybe each one of you can briefly introduce themselves to our listeners as to who is Gretchen, who's Pamela, and what do you do, and do you find the property industry boring, or is it hectic, or is it lovely, or do you enjoy it, or what is going on?
So I'll just start off. My name is Gretchen Enslin, and I'm a senior associate at STBB Bedford View. And I must be honest, I always thought I would go into property just because as an attorney, I didn't have the appetite for litigation. And I always thought maybe that would be the easier option for me to take. And to be honest, it's anything but boring. I think it turned out to be, as much as what I enjoy it, it's also very much a challenge, just because you deal with people's personal circumstances and also with their biggest investment at the end of the day. And that makes it a huge responsibility.
Wow. Okay. And how long have you been doing what you're doing, the conveyancing?
So now this year I'm going for my 6th year.
Oh, wow.
Amazing.
Yeah, so I'm gonna hand the mic to my friend and colleague.
Yeah, let's hear what's Pamela up to, and how has she gotten herself involved with the property profession or industry?
Yeah, thank you. So my name is Pamela Makubela. I am an avid runner. I have to say that.
As in, like, physically?
I have to recruit somebody to run, and I hope one of you guys will join me one of these days. But
but Pamela, I mean,
convinced.
There's a lot of ways to do cardio. I personally cycle, so
Love it.
Yeah.
Oh, I love it. We love that. So I am a professional valuer. Before I became a conveyancer, actually, I studied property valuation.
Mm-hmm.
And I am an attorney, conveyancer, and soon to be admitted as a notary.
All right. Nice.
And I am situated and I practice at the STBB Ilovo branch.
Oh, fine.
My thing about property, it kind of found me. I think over the years, I've always wanted to do constitutional law. I wanted to go into the constitution of things. But as time progressed and life would have it, I later studied property valuations. I became a property valuer and then did my articles later in law to then become an attorney and conveyancer. But one of the things that I've learned over the years that I've particularly loved about property is that essentially it's still a constitutional right. It's such a wide spectrum when you say the Constitution. Mm-hmm. The Constitution is an umbrella of a lot of rights. And in itself, property, it's a constitutional right. Property is a language that not a lot of people understand. And specifically coming from a previously disadvantaged race, you know what I mean, from where we come from. And so I've always thought one of the things I can do is to go in and I have an appetite and I'm such an extrovert and I love people. So I figured if I can get that information, then I can navigate that information and basically deliver it to people and take it to all communities and take it to my social circles and take it to. And one of the most beautiful things I did recently is get my dad his title deed, and that was the most beautiful thing. And again, I'm serving as constitutional right, so that's property for me. I serve on the board of the Property Practitioner Regulatory Authority that's just been appointed, and that's the new chapter. That's the next chapter that I'm about to embark on. But very excited as well.
Oh, that's amazing. I'm actually studying the whole property valuation stuff, but purely because I'm a teacher's daughter and I just have a nick for studying more. I'm not quite sure what I'm going to do with it. I don't see myself going around, trying to check out what the value of a property is.
Measuring.
I find that's too labor intensive. I mean, they can throw you anywhere in Joburg, and some places are not necessarily desirable. So I'm not quite 100%. Sure, but I'll definitely do it really more for the information and what else it can do for me. But yeah, it's quite interesting. How then did you actually transition from the point of being a valuator into law?
So I had a bit of an interesting story. Law was really something I fell in love with, and at some point during my course of studying it, I lost interest. Life throws us a few things while we're in varsity.
Of course.
I actually got excluded from varsity.
Which varsity was this one? I feel like it was Wits.
Yeah, it was hectic.
Which university was this? I'm sure it was Wits.
Yeah, and so we know how life will go through some curves, but I learned from it.
Yes, well done.
So when I moved home, I actually was lucky enough to be a data collector for valuation. So I got into valuations, and then I decided to complete my law. So I graduated both qualifications, and then I was done. But when I was busy with while I was busy with valuations, we were attending something called appeal boards, where people object to evaluation and then it goes to appeal. But the panel that sits on that board is usually attorneys or let's say legal practitioners, advocates and so forth. And there's a gentleman that spoke to me and said, look, if you're a law graduate and you're really not admitted, you're limited in what you can do. So I would suggest that you kind of pause and go do your articles. And so as a result, in that moment, I made a decision the following year that I'm going to start doing my articles so I can be admitted as an attorney. So that's how kind of that transition happened. But I continued then to write my professional associate valuer exam at the time, and I qualified. So at least that was kind of, I wasn't leaving things hanging there. So that's how I kind of transitioned into it.
Oh, that's lovely. Now I think let's get straight to the business of the day.
Yes.
We've got a new act, the Property Practitioners Act. Um, Maybe perhaps if you can tell our listeners what is that act, and what was it necessary? Was it needed in the industry? Did the industry need something like this, or do you feel, as a person who's been doing this conveyancing for a while, um, do you think this was necessary? What is the Property Practitioners Act, and why does the property industry need it?
So the Property Practitioners Act is actually a wonderful development in the industry. It's just been decided that the current Estate Agency Affairs Act just was too dated. And at the end of the day, the new act that is taking effect means that now consumers are better protected at the end of the day.
Mm-hmm.
So it really looks out for the interest of the general public. And now, as of late, it doesn't only cover estate agents, but it covers more individuals or different professions that is covered by property, who deals with property. It could be a mortgage originator, for example, or a valuator. So now, for estate agents, I guess, it's new in a certain sense, but a lot of the old has, in fact, been incorporated in terms of the code. There are a few extra things, but I think for the newcomers, for the, mortgage originators or the valuators or whoever, for them, I think it's maybe a bigger thing to get used to maybe than our estate agents.
Okay. But do you think this was necessary to be done? Was the old code of conduct not enough?
So I'll take this one. So I'll take you to what the history of it is, right? And Zanele, what happened there was that when I think it was 2019, where the minister at the time, right, said, look, we have an act that was born, basically, it was an act of 1976. Okay, so you're sitting in at that point, let's say at the time, we're sitting in 2019, which is 40 years later plus now. Number one, it's archaic. That's the words used. They said like it's an archaic law because it's a law that was drafted so many years ago that it doesn't really resemble anymore to what the South African market looks like anymore.
Okay.
Right? And then secondly, and then it spoke to number two, he said the transformation factor of it doesn't speak to transformation. And South Africa is a transforming country which embraces the Rainbow Nation, which embraces integration, which embraces change and innovation. And then he touched base on the fact that innovation it must play a factor. And that's how then that came in that, and again, what Gretchen then says, lastly, he said the consumer. So the old act in its place, look, it did a good job. We can't take away from it. But we're saying that it started not being very practical in where the world is right now and where South Africa is in the property industry. So that's why then the act was very necessary. As you know, it's respective industry needs to change and move with the times and needs to evolve with innovation and transformation as the rest of the country is.
Yeah. Wow. I hear you, and you are right. Because fashion changes, cars are made new, so why can't the property industry get something new like this? I think it's a breath of fresh air as well. I think we needed it in general because as I understand the old code of conduct, like Gretchen was saying, like people could get away with a lot of things who are not estate agents. So I get it. Like, just quickly, speaking of transformation, I'm very curious here, ladies. Transformation, you mean everybody has to be BEE compliant, right? Is that what you mean?
So basically what it means is that every estate agency must have displayed in their window or somewhere where it is visible how BBBEE they compliant they are. So, for example, if government institutions, by way of an example, want to elicit the services of an estate agency, that it is clear up front how much they comply in terms of that.
Yeah. And that's clearly stated. So basically, we don't want to obviously delve into like the BE lessons, but in that depending on which category you fall under, you know, then they will say whether you must have an audit that must be done or so forth. But the point is, it is an obligation on an agency to be BE compliant. That is no longer going to be, it's non-negotiable, and the PPRA will hold estate agencies that are not willing to move with that. They will be accountable. So the PPRA encourages it. The PPA is saying that, look, let's work together. So now it's an obligation on the agencies to be compliant.
So it's encouraging diversity, basically.
100%.
So,
Definitely.
Pamela, I'm going to need you to please explain the whole BE story for me. So BE compliance means that you have to have what exactly? I know employees definitely, or management or something. Can you just please explain it more? Because as much as we've been hearing about this, I mean, I remember at school in matric, business studies, everything, it was always sung about how it's important for a company to be BE compliant for you know, ability to be able to work with the government for better opportunities and all of that. But in this case, how would you classify a company as BE compliant? What does it need to have for it to be called BE compliant?
Okay. So, I mean, there are ratings, right? And I mean, I'm not a BE specialist, but
you definitely know more than I do. That's what I can tell you.
there are ratings that basically we look after. So, for instance, you have, I think, the SMEs, where then you would say that if they earn less than 2.5 million turnover in a year, those agencies are basically they don't need an audit. They automatically kind of get a BE status of some sort, right?
Okay.
And then you go further. You get the QMS.
So that's purely based on earnings only.
Yeah, no. So not only on earnings, but this is me directing maybe agencies on how to get audited. But the point is, always go to a specialist. There are audit firms that can do this for you. However, what I've been telling clients is that as an agency, you only think that BEE speaks only to how you employ. That is not only the case. Number one, look at your suppliers, right?
Yes.
If you use, let's say, Pamela for your paper, who delivers your paper at your offices, that there be your suppliers being a BE compliant and you supporting small businesses that are probably at a high level of BE, that gives you a point too.
Yes. Okay.
Understand? If you are running charity cases, of course we do it for the bottom of our heart. But I mean, at the end of the day, you also look at what are you putting in as a business. But we do it obviously, like for instance at STBB, we have every year this Run for Smiles, where we raise funds for children with cleft palates and they then cleft lips, and they then later get operation, and we raise funds out of that. In getting that together, we use suppliers, we use people that we know, and that is something that can give you a BE score up. You know, so there's so many things that you do, and so also for instances with agencies, right?
All right.
Conveyancing agency, your agencies that are selling property, right? Say they have agents.
Yep.
They have something called panel attorneys, for instance, like Gretchen and I, right?
Yes.
We work for STBB. So they will have a Bridget and Zanele attorneys, or they'll have Pamela and Gretchen attorneys, or they'll have STBB. Now, looking at that firm, at Bridget and Zanele attorneys, if their BE score is at a high level, that already counts to your advantage because you're using a BE compliant. And STBB, for instance, Joburg here, we are level 2.
All right.
And that's pretty high. So already your panel attorneys support you and it boosts your BE status. So it doesn't work only to what you can see with the naked eye. There's so many other things. I mean, even just getting your painters in to come paint your building. If you get a company that is BE compliant, that's at level 1, great. That you get the certificate that works to your advantage.
So you get benefits by association even.
Exactly.
All
And
right.
if you think about it, it already supports that integration of diversity, because by motivating and encouraging businesses to say, utilize the skills of other people out there. And if you utilize those that need help and assistance and all that, and you work hand in hand, then diversity is happening already.
Wow. So what penalties do companies get for not being BEE compliant?
Look, at the end of the day, I think just one thing we need to state is that there is no requirement as to a specific rating. But obviously, it's in the interest of the organization to try and work towards a very good score. Because as I mentioned, at the end of the day, that's something when, companies or individuals or maybe government institutions, when they want to elicit your services, that's something they're going to look at. And that could disqualify you, obviously, in getting or securing the necessary business. So from that point of view, you penalize yourself at the end of the day by not being compliant.
Okay. Fine. So you're basically blocking opportunities for your firm.
Exactly. But that's not the main thing what the Property Practitioners Act is about. I mean, that's one of the things, but also it speaks a lot to, like Pamela already said, to the consumer. And you guys will remember last week, I mentioned the fact that it's now obligatory that a disclosure form must be completed at the end of the day, whether it is, a lease agreement or a sale agreement. The disclosure form must be attached to that document. And I believe you also had a question from one of the listeners, and they asked whether, an agent would be liable, as to the contents of that disclosure. The answer is actually quite simple. You as an estate agent, you basically expose yourself to liability when you fail to ensure that a disclosure form is completed. And also you have to sign on that disclosure form. But if, say, it wasn't accurately completed, then that is where the seller will expose themselves to liability. Because at the end of the day, you as the estate agent, you're not living in that property, and you can't guarantee everything regarding the condition of that property. That is the obligation of the seller. But as an estate agent, we cannot emphasize it enough that this is something that cannot be neglected.
Yeah. So this is a must. This disclosure form actually, I find it very. It's very good for people who are buying properties. But what I want to know, Gretchen, the question actually is, if this disclosure form is not signed, who is held liable if it's not signed at all? Is it the seller or the agent or the agency?
Look, at the end of the day, those are the kind of situations that the Property Practitioners Regulatory Authority will still need to decide on. We are just saying that the disclosure form must be done, full stop. The problem that may arise if an agent fails to do this, if now the buyer comes back and says, they raise a whole list of concerns regarding the property, then the agent could be personally liable to that buyer, with respect to that damages that now seem to have been on the property, and, the agents didn't ensure that the seller completed that disclosure.
And further to what Gretchen, if I may just jump in, further to what Gretchen is saying, one of because of the PPRA and what we discussed, it's going to be now an obligation for instance, if I get a transaction from an agent, Agent Zanele, and Agent Zanele says, here's the sale agreement, please will you process this transfer? It's an obligation for me to ask for that disclosure form. That disclosure form is now an obligation on each and every single agent. So in essence, what we're probably saying is that if there is we're talking about compliancy, right? If you comply with giving us the disclosure form, but if out there is a situation where someone processes something like that, then the PPRA has set down very strict very strict sanctions to that. You can lose your license. They've really gone to those lengths. You can get a high fine. You can get you can end up being in a position where you're basically getting imprisoned, depending on the damages. So the liability now is higher. So it depends. And obviously, the law is never really, we'd love it to really be black and white, but it's such a gray matter. Everything will work depending on the circumstances of each party. Because sometimes we'll have a disclosure form that was completed, but a problem still arises. Now we still have to determine who withheld the information. Was it the seller? Did the agent act within reasonable, like the reasonable man? Did we look at each situation from with its own merits.
And if I can interject there, the other thing is also that there's now a complaints procedure in place. So if the agent does not abide by the code of conduct, the consumer out there is obviously going to be made aware of their rights, and they can actually approach the Property Practitioners Regulatory Authority, and basically, or there's the necessary platform is created by which they will determine whether an agent was at fault. And this service is provided free of charge to the general public out there. So I think knowing as an estate agent that, the general public out there, they have this option at their disposal, I think will help a lot of agents to step up their game at the end of the day.
Yeah. Wow. No, that's true. Now, I think Zen and I had this discussion before, and Zen tried to explain to me this whole disclaimer form, because my question is, how long is this disclaimer form enforceable? Like, after how long can a person not come back and say, yeah, but you said the roof is not leaking and this is not broken? Like, is it open-ended, or is there a certain period where, okay, you move into your property, everything is in order. Come 3 months later or 6 months later, you get a roof leak. Is the seller still liable?
Look, at the end of the day, if you look at if you look from a litigation point of view, someone has got a claim for pretty much 3 years, before it prescribes. Okay. So I think, and that's the thing, the beauty of law, it all, joins in together. So that is something to bear in mind. Look, at the end of the day, foot stewards, what it means also is buyer be aware. So even though there's an onus on the seller to complete a disclosure form, what foot stewards essentially means is that when you as a buyer, you go view a property, the onus is still on you to go do a proper inspection, because any sort of defect that you could have, come across by virtue of a decent inspection, then if you come afterwards and say, look, there's a big crack in the wall, then, everyone's going to, raise their shoulders and say, but you had the opportunity to view the property. We didn't hide the crack in the wall from you. It was there for you to see with your bare eye. And therefore, the seller can invoke the protection of foot stewards.
Okay, yeah, that's actually quite interesting that you should bring that up. I hadn't thought about it. But then it seems those two clauses will fight against each other. What do you think, Bridget?
I think so, because the seller can come back and say, yeah, foot stewards, and then the buyer...
You're buying it as it is. But then again, at the same time, with regards to your question, Bridget, the question that I have there is, today I can move in, or rather there is everything has got a deadline, right? The perfect house with no leaking roof will eventually start to leak. So what if I sell that house and at the time that I'm selling, it does not have that leak, and maybe 2 weeks down the line, then it starts leaking? You can't necessarily say that the seller hasn't, things like this would probably happen. You can't say that the seller didn't disclose that there is a leak because it wasn't there at the time that you viewed the property.
Or even a year later, that's my question, like how long is this thing enforceable? Like,
exactly.
Is it open-ended?
It definitely has to have a deadline.
Then maybe 2 years later, the house is leaking. You want to go back to the seller and say, now the house is leaking. You didn't tell me.
If I can say, I think these two, call it opposites, they don't really oppose each other. I think what we need to gather from this is that no party can be complacent. The seller cannot be complacent and not disclose anything, but the buyer cannot be complacent and not go and do an inspection at the end of the day.
Fine.
Because this PPA actually also provides for the buyer to the buyer is allowed to have their own professional inspectors to come through to the thing.
Yeah.
So I guess also it's up to estate agents to educate their buyers about this new Property Practitioners Act. I think so.
Yeah, and I think it's also one of those situations where we need to also say to consumers, take responsibility as well. Make it a journey, make it an adventure. When you start, and I'm obviously, and then situations arise, but on a more, let's just say, ideal day, and you're deciding that Bridget Roseanne is going to go buy a property, do the research, ask questions. And I mean, one of the pointers and the advice we give on our platform with Gretchen is that when you go on the first day and you're going to view a property, you ask questions, ask the agent, ask the soon-to-be property practitioner, ask the owner, open the cupboards, take your time, process it. It's okay to do that, because the reality is once you sign on that dotted line, you've sealed it. You've sealed it, because the truth of the matter is, if that leak comes up and the seller says, it wasn't there, you've bought a property with that leak.
Yeah. Wow.
That's just because it's ideally we would wish that everyone was buying a brand new house, right? Because then we would know that, well, everything is brand new, but that's not the case.
But even if it's brand new, it's still, it's still a product that's created by human beings, so it's still subject to,
exactly.
Flaws.
And I like this disclaimer form. I like this disclosure form that they've come up with. I really like it, because
I think I have to agree with you there.
Yeah, because it's then going to create that conversation between seller and buyer, because seller's going to say, hey, I'd rather tell you the truth right now, because I think maybe agents even need to say to seller, look, I know you want to sell, and just give me the harsh stuff right now. Give me the real truth, smash me with it right now at the beginning of the transaction. And once that's in place, then
Yeah,
you know what I mean?
True,
then
Yeah.
And the purchaser can then, and you approach the purchaser, and you can even negotiate from a point of good faith and say, hey, buyer Pamela, I understand that this is the house, and at that point they can even agree on certain things. They can say, okay, will you please fix the leak? Of course I'll fix it. You know what I mean? There's that engagement starting to go.
Yeah.
It's opening up into action, and it's opening up opportunity for sellers and buyers to actually engage from the get-go and just be transparent with one another.
Yeah.
To more honest transactions happening in the future. That's what this is.
Cheers to that. Yeah.
Yes.
To our listeners, feel free to send us questions through our WhatsApp line 084-092-9990. You can send a voice note and a text or an email to thepropertyhour@womanr.co.za. It is now 17:41. I think we had a question via voice note that was asking, what happens if the seller fraudulently fills in the disclosure form? Will the agent be liable for that fraudulent disclosure form, or is the seller now liable for lying? Who is lying? Because now the buyer doesn't know. I sign an OTP with a buyer. I go to the seller. The seller will obviously have filled in this disclosure form when you take the mandate. Yeah. But then you discover that the seller lies. You go back to
the seller lies, then they're the ones that are.
What do you think, Gretchen and Pamela? Like who
have to be?
Who must go to jail?
I say seller must go to jail.
At the end of the day, we can't really hold the agent liable. Let me just start by saying that if a seller didn't complete the disclosure honestly. If now after transfer it appears that the roof is leaking, then, obviously the conveyancing attorney needs to go back to the seller and say, Mr. Seller, we noticed you didn't disclose on your disclosure form that your roof is actually leaking. Did you know about the leaking roof at the time when you concluded the sale agreement? And look, yes, obviously there are unfortunately those individuals which would say, no, we didn't know about it. And in fact, they knew about it, But it's a difficult situation to be in as a buyer because the onus would be on you as the buyer to prove that that seller knew about it.
Sure.
And if you, with anything, when it comes to litigation, if something starts getting litigious, it ends up costing you a lot of money. And it's something that a buyer, where you have to face the difficult decision of, am I going to pursue this matter and go the legal route? Or would I rather take the money and just fix the roof?
Yeah.
Obviously each situation is different. If you calculate it, you will get to different amounts. We also know that litigation is not a cheap, route to follow. And that's why I can just re-emphasize what Pamela said, because I actually bought a house probably a year and a half ago, and I understand the situation that buyers are in. When you go view a property, you almost a little bit on the back foot because now you are in someone else's home and you need to now, in an hour's time or however long, time you are afforded, you need to go and do this inspection. And that's why I advise buyers that maybe rather arrange for a second viewing if you need to a third viewing, just to go back, because like I said, the first time you go there, you might feel overwhelmed.
Yeah.
And we also, few buyers realize this, but they can also elicit the services of a professional property inspector and have a proper inspection done. So in my situation, you won't believe me, and I'm no exception because I'm a conveyancing attorney. My roof did leak after I had bought. So my house registered in September and December. We had so much rain, and I promise you, I had the Vaal River in my house. I was sweeping the water from the front door. So, I was no exception to that. And I realize now, looking at my house probably a year later, there are those little telltales of, where there could have been a water issue. But like I say, you just feel as a buyer a little bit on the back foot. And that's why we say, if you don't want to pay for a professional to help you with the inspection, ask for a second viewing. And if you need a third viewing, do that.
Yeah.
I think the other side of the coin, if I can just add one extra thought, is I think on the other hand, buyers must also understand, yes, sometimes we feel a bit done in maybe afterwards about something that's gone wrong with the property, but we must also be realistic in our expectations about the property. If it's maybe a leaking toilet and it's going to cost you 200 Rand to fix it, and I don't want to sound blasé about 200 Rand, but no property is perfect. No property is perfect. Like you pointed out, it's created by a human being. Even for a new property, you'll find 9 times out of 10, there'll be a snag list.
Yeah, there always is. It's interesting how, we all always say, I'm only human, and we expect everybody else to understand us. But then when it's us who are in the receiving end of whatever product, we want to make sure that that product has to be perfect. So, it's very interesting. It's human nature anyway. Gretchen and Pamela, do you, those guys that flip properties, those guys that make a lot of money, they run around with auctions and gazettes and all of that, are they regarded as property practitioners as well?
What would you term them? The question is, to clarify, look,
speculators.
I would say that, remember the rule of thumb is that if there's a transaction, if you engage in your daily business, in the business of property, and you earn some form of benefit from it, that act does include you. It does apply to you. because you are working. That is not just only a property transaction, that you do this as a business. So the fact that you are gaining a benefit from it automatically means that you are covered by the act.
Like a developer, if a developer develops a stand,
Because that's what you're doing, essentially,
and
developing.
you selling those properties and those stands. So that would also,
To speculate, actually, that's what we call it, because you're basically you're developing a property to a better state. Or either, it's only a developer.
Those ones lie somewhere in the
scratch,
cracks. I think they actually belong to that side of being a seller mostly, because they see the equity that's sitting in a property, and then they hand over that property that has got this value that they've now discovered, and they give it to an agent. So obviously, because the property is given to the agent by them, they are liable, especially for that disclosure form and all of that. So to a degree, they will find themselves caught up in it. But then I don't think there's a clause that actually specifically hits them only. No.
Yeah.
No, but remember, that would be us using layman terms. Because if you look at the definition of what a property practitioner would be, that's how they got there. If you are in the business of a transaction that where you have a benefit, and this is not necessarily this is not your hobby. Like you can't call it a hobby. The essence is that there's a transaction here and you're getting a benefit out of it.
Yeah.
And so by virtue of that, you might obviously then say you're not covered by you're not regulated by the act. But the fact that you keep doing this over and over and over again, it starts being a business in its essence. So we then say, because there's a benefit that accrues to you by virtue of this business that you are involved in, then that actually makes you a property practitioner. But however, what we are doing, because this is a new act, and by no way do we say that we are the legislature. We didn't write the act, but we do have access to people that drafted this. So that for me already is an interesting point that you brought up, which I'm going to put on my notes right now, so that we can in the future go engage the authors of this legislation and say, so why do we talk about people that actually just kind of, because to us in our business, we say you are developing. But then we want to say that we want to be clear to people that where would we classify them as. So it's a good point that you've raised, and we'd also I will further engage the people that we engage with that drafted the legislation and the board in identifying that we may have people like that, obviously, because that's what we see in our daily.
I've got another one. I've got another one that maybe you can take note of. The people who are doing property inspection, are they not?
Who regulates them?
Who regulates them? Don't they fall under property practitioners?
We have to look at the definition.
Yeah, we'll definitely look into that. I think just to add to what Pamela said, you have to look at if something is a once-off sale or it's a once-off spotter or anything, to that effect. Those individuals will definitely be excluded from the act. And the key thing that Pamela mentioned is in your ordinary course of business. If you are making a business from flipping properties, the general feeling is that you would definitely then be included and fall under the act.
Oh, okay. So does that mean these speculators must now have an FFC?
Yes.
Wow.
Yeah.
If you're regulated, and that's the thing about the PPA now, its scope is going to be so much wider.
Yeah.
And yes.
Yeah.
Okay. So okay, that's quite interesting.
Yeah. It is.
I don't think actually a lot of them don't know this. I
They
must be
don't.
honest with you, because the way I've seen those guys, the way they live, they live like thugs.
Yeah.
I'd like to say they just wait for that gazette to come out on Friday. No, I'm serious. I've seen a few of them that actually do this thing.
They are so gangster.
They are
so
very
gangster,
and they've got a lot of money, and it's just like that money that just flows into a bank account, and people just question, okay, how did you get there?
Yeah.
So then how do you actually creep up and reach out to them, because they're just somewhere in the gutters and hidden under the tables somewhere, but they are making the biggest money within the property.
Yeah, and I also think that I don't know how this can be enforced, because some people buy these properties from speculators via estate agents, and then the agents don't tell these people that, look, this is now you are buying this property from this guy who who has an FFC.
Yes.
If you're not happy about such and such, if they treat you badly, you can report them to this.
But then again, on that end, if they've got an FFC, why do they need an agent still?
Because they can't sell then. They are so gangster.
But remember, at the end of the day, if they, that's something that the general public should also can ask for. They can ask to see that FFC. Interestingly enough, if you're an estate agent and you don't have an FFC, the conveyancer is not allowed to pay you your commission. So and as of with the new Fidelity Fund certificates, those will now fortunately be valid for 3 years, which does make it, from an administrative point of view, at least a bit easier. In that respect.
Yeah, but I have found that most agents are paid by their agencies. So the agency gets the money from the conveyancer. So how are you going to know that the agent has got the FFC for you not to pay them?
So one of the things that I'll make an example. And I think I should think that's what's going to happen. But with for instance, with what we're going to do, what we're putting in place potentially, is that when we get a mandate or an instruction from an estate agent and a seller, we are going to request the FFC.
Okay.
From the get-go, before we even start managing the and opening up your file and whatever, we get an instruction, a sale agreement. That sale agreement must be accompanied by an inspection form, which is a disclosure form, and an FFC.
And important to note is that the Act also requires that the FFC must be made readily available for customers to inspect, and the certificate must be prominently displayed in every place of business where they conduct property transactions.
So and remember now, the challenge is that if we don't adhere to that as conveyancers, we could lose our licenses to practice.
You lose your whole degree.
Basically. Because in essence, you are given a directive of an act, and I mean, I should think that I am a symbol of law. For instance, I owe it to adhere to it. So you can imagine now, a consumer comes up and goes to the PPRA board, complains about a transaction. Turns out that the commission was paid by Pamela the conveyancer, and they come back to Pamela the conveyancer and say, "But why did you pay that? That's a contravention of the law."
Yeah,
so you can understand how that would be. So moving forward, it's an obligation that with any transaction, you cannot pay it out. And most of, like you asked whether most of the time the agency pays it. The commission, when we get an instruction from a client, we ask for the income tax number, and we ask for their details on how the commissions have to be paid out. But one of the things we're going to ask for is an FFC. It's an obligation, and it's a directive from the highest board that regulates estate agents. So we can look at any other way and say, hey, but that's what they did. If you pay out that money and the estate agent doesn't have an FFC, then you have basically broken the law.
Yeah, so you basically lose your degree.
So then who gets the money since the agent?
So until it does stay for a bit with the agency. With either it can go to the Fidelity Fund. It depends what has been decided on it. Sometimes you find that the Fidelity certificate hasn't been issued. Fidelity Fund certificate hasn't been issued based on certain reasons. So we'll hold back on it until we get a directive from the PPRA.
Wow, I think, ladies, we're going to have to thank you and say goodbye to you. So how do people get more information on this? Have you got a website? Have you got your details? Like, what do we give our listeners out there?
So Pamela and I actually have our own platform on YouTube that the listeners can follow us. It's called Gretchen and Pam on Property. You'll find it under the STBB YouTube channel. So we like just sharing useful tips with our general public out there. And in addition to that, they can look us up on www.stbb.co.za, and you'll see there a tab called Find an Attorney. And you could look either Pamela or myself up. Our contact details are there. And yeah, we'd be happy to take questions from the listeners if they wish to contact us.
Okay, we hope to speak to you again in the future, Gretchen. I think we've got a whole lot of things that we can talk about, not
Yeah,
only these property
definitely.
practitioners. So we're gonna have to say goodbye to you guys. Thank you so much for listening.